Matthew Borke versus Kelsey Warren, 22356 CZ.
The court is opening court today for purposes of delivering a decision on the motions for summary disposition that were filed by all defendants in this case. The grounds for those motions were under MCR 2.116C1 related to personal jurisdiction, the statute of limitations, MCR 2.116C7, and failure to state a claim, MCR 2.116C8. As it relates to the statute of limitations, the incidents alleged in this case occurred in 2017. The federal complaint was filed, the plaintiff filed a complaint in federal court on October 13, 2020. And that complaint contained 4 claims or counts. The first was for violations of 42 U.S.C. Section 1985. Count 2 alleged Michigan civil conspiracy. Count 3 alleged Michigan defamation, and Count 4 alleged the Michigan tort of false report of a crime. The federal court case was closed on February 22, 2022, on the federal court's grant of summary disposition with prejudice as to Count 1, again 42 U.S.C. Section 1985, and was granted without prejudice as to the 3 state law claims. Plaintiff filed his Michigan complaint in this court on March 29, 2022. That complaint alleged 2 causes of action. The first is characterized as common law tort, and the second is conspiracy/concert of action. The substance of the allegations in Count 1 describe both general negligence and false report of a crime. After the complaint was filed on March 29, 2022, defendants filed for summary disposition, and before hearing on the summary disposition motion, plaintiff filed his first amended complaint on December 29, 2023. That complaint alleges as Count 1 false light. It references 5 dates, 2 of which are prior to October 13 of 2020. Prior to October 13 of 2017. I mention that date because all of the torts alleged have a 3-year statute of limitations, and the federal complaint again was filed on October 13 of 2020. So dates occurring before October 13 of 2017 would have no chance of being told by the filing of the federal complaint. The second count of the first amended complaint is again concert of action / civil conspiracy. Neither of the state law complaints articulates a claim for defamation. The plaintiff said at page 21 of his combined memorandum to all defendants' motions to dismiss that he abandoned his claim for defamation to promote judicial economy. The plaintiff's claims for common law tort and general negligence as I said, describe a false report of a crime. That claim was not articulated again in the first amended complaint and is considered abandoned. So the court analyzes the two claims for false light, the one claim for false light and the claim of concert of action, civil conspiracy. As I stated previously, two of the dates alleged for false light are prior to October 13 of 2017, and those dates, I believe in July of 2017, the court grants summary disposition as to the statute of limitations, as there's no possibility that those claims could survive the statute of limitations. The court will deny the motion for summary disposition on the issue of the statute of limitations as it relates to dates after October 13 of 2017, to the extent that those claims were preserved or were first articulated in the federal case and were preserved when the federal court dismissed those claims without prejudice. However, the plaintiff articulated the claim in the federal complaint as false report of a crime and not false light. So the only possibility of a claim that plaintiff might have remaining is that of concert of action or civil conspiracy. And concert of action or civil conspiracy cannot exist without a predicate tort. Where the plaintiff has not preserved any claim for false light or defamation, it cannot be the predicate tort for the concert of action or civil conspiracy. Furthermore, pursuant to MCR 2.116C8, the court finds that false report of a crime is not an actual tort in the state of Michigan, despite the plaintiff's argument that the criminal statute criminalizing the false report of a crime is intended to benefit the person accused of a crime. The court finds that that is not the intent of the crime. The crime or the activity is criminalized to conserve police and prosecutor resources. Even so, their plaintiff has not articulated any authority for his position that if a thing is a crime and that thing happened, that it can also be the basis of a tort without any other legislation directing so. As it relates to the claim for false light, the elements of false light require that there be a broadcast to the general public or to a large number of people. plaintiff has failed to make a showing that either of those conditions is present. The alleged audiences of the communications were small and, in one case, one person, and insufficient to sustain a claim for false light. So the court also would grant the summary disposition as it relates to MCR 2.116C8. As it relates to personal jurisdiction, this was analyzed by the federal court in its opinion granting summary disposition. The court finds that the plaintiff has established personal jurisdiction on Energy Transfer, Latent Security, and Gary Washburn, consistent with the rulings of the federal court, and that plaintiff does not have personal jurisdiction over Kelsey Warren or Kevin Mayberry, also consistent with and for the reasons articulated in the federal court decision. Considering defendants' various arguments with respect to C1, C7, and C8, the court then grants summary disposition of all claims made by plaintiff. And the case will be dismissed. The court will enter an order.